The Senate Judiciary Committee will come to order. The clerk will call the roll.
A quorum is present, Mr. Chairman.
Okay, a quorum is present. Everybody please take their seats. The first thing, we got two bills. The first thing I'm going to do is move to reconsider House Bill 2254, Senate Delegate Kelly Converse Fowler.
Mr. Chairman?
We defeated the bill last Monday, I believe, but we've had a meeting since then, and therefore it's unanimous consent is required in order to reconsider the bill. And I voted in favor of it, so I can't move to reconsider. Senator Morrissey?
Thank you, Mr. Chairman, and good morning to you. Mr. Chairman, having voted on the prevailing side in which House Bill 2254 was defeated before this committee, I ask that for unanimous consent to reconsider the HB 2254.
Okay, keep in mind there's unanimous consent. I've talked to Charles. He thinks he has a fix for the bill. In any event, all in favor of reconsidering Senate Bill 2254, which is Delegate Kelly Converse Fowler's bill. All in favor of that, vote aye. All opposed, no.
Ayes 9, noes 2.
Okay, ayes 9, noes 2. It is not reconsidered. It's not unanimous. And that's where we are. Okay. So we will not consider House Bill 2254. It did not get unanimous consent to reconsider. All right, we now have Senator Delegate Watts' bill, 2155, House Bill 2155 that's before you. Delegate Watts.
Yes, Mr. Chairman.
Welcome.
Thank you.
Good morning.
Yes, right.
I think there is Charles, do you have a amendment?
Mr. Chair, yes, there are some clarifying amendments to this bill. The amendments have been posted to LIS, and basically there's three amendments. The amendment is on line 116, striking the word engage, inserting the word discriminate by engaging. Second one is on line 145, sexual, inserting workplace. And then the last one is on line 148, after contribute to, striking the remainder of that line through harassment on the next line, and inserting a hostile work environment. And those are the three clarifying amendments that I believe Delegate Watts would
Okay, I assume Delegate Watts, you have no objection to that?
No, sir. Thank you.
If these are all clarifying, correct?
Correct.
Is there a motion to adopt the clarifying amendments?
So moved.
All in favor say aye. Aye. All opposed, no. Motion carries. Okay, Delegate Watts, present your bill.
All right. Thank you, Mr. Chairman. And I did send an email to members, and so I'm going to repeat the start of that email. I do appreciate the courtesy of the Senate and of you individually in hearing this bill. It is a courtesy that is much appreciated on my part, and mostly because there's a confusion on several points as to how this bill differs from the bill that was considered by the Senate. Let me start with just this quick perspective. It was September 2017 when the Harvey Weinstein history began being revealed. In November 2017, the House of Delegates went from 16 women to 28 women. In the last election, we now have 31 women. This is a sea change. And I believe that Virginia's statutes need to be in line with that change. I will explain as I go along reasons for that as I see the action that harassment may bring forth. First, let me just clarify, as I did in the piece that I sent you, and I've also appreciate staff having circulated that if you wish to follow along this morning, because I know I have problems sometimes just following people referring to lines in the bill. But in the House Bill 2155, as it passed the House, there was major help from the Department of Legislative Services attorneys, particularly Brooks Braun, in restructuring the bill so that harassment is the ninth of a list of 8 discriminatory practices that are set out in 223905. And again, the title of that is almost self-explanatory: non-discrimination in employment, definitions, exceptions. Harassment is a form of discrimination. The problem that we have, however, and again, in the list of 8, there are at least 4, I would say 6, that directly open the consideration to harassment, but we don't define harassment. And that is why adding a subsection 9 is very important for both, for all people in the workplace, most importantly, employers and supervisors. Now moving to the employer liability. And this is my second year with this bill. When it was first brought to me by the administration last session, I said, yes, again, given the Me Too movement, yes, I will handle it, but only if it covers all classes of discrimination, not just a sexual harassment. Therefore, my living with this bill for the last year primed me to be I think it took 10 minutes, if that, to respond to a very respected attorney who represents a number of business interests that I've worked with over the years, when he called me on that early morning and said, you really need this amendment so that employers know their liability and they know how to prevent liability. Without question, I added then the definition that was provided by the lawyer after looking at what the Department of Law case studies would indicate. The language that you see then on lines 137 through 159 is the black letter law reflecting federal case history as far as employer liability, so that it's not a black box, it's black letter, and it's not a catch-22. It says, here's the activity, here's what you can do to prevent it and erase your liability. But in so doing, you will also see on lines 160 through 162, by the time we got to full committee that afternoon, I felt it was very important to also insert, since number 1 and number 2 of the employer liability include vicarious liability for acts of a supervisor, that we use the definition of supervisor that is used by the Department of Law, and that is what you will find on lines 160 through 162. And now on the EEOC language. As I have listened to the debates, and yes, I did go back into the archives and listen to the committee's deliberation on Senator McClellan's bill, both in this subcommittee and in others, there is a real confusion about looking just narrowly at the definition of workplace harassment that you will find on lines 42 through lines 50, as if that just was the offense. No, as in any other statute, these are definitions that then apply to how you describe the offense. And so that I draw your attention in particular to reading those words, as well as the employer liability language, in the context of lines 116 through 136. And there you will see, again, reflecting federal case law, again and again, that you look at the totality of the circumstances in the aggregate, viewed in the totality rather than in isolation, including the frequency, duration, whether the conduct is threatening, the power of differential, etc. There are many, many parameters that are within this element of the bill that are extremely important when we're looking at how this how the language on the employer and supervisors liability will be seen by through the process. Before I move to the process, let me also underscore two other things. One, the definition in the House version on line, I believe it is line 48, includes unwelcome conduct, which is different from what the Senate version is, and I think a very important distinction when we look at the type of behavior that goes on between individuals. I will also point out that House Bill 2155 does not contain any enhanced award for litigation expenses that are in the Senate bill. And then finally, let me address the whole issue, and Helen Hardiman from the Department of Law is here to answer any questions that members may have about how the process goes forward. Once you determine that harassment may have occurred, then the department is looking, it goes into investigation, mediation, conciliation, training, the whole emphasis being first and foremost prevention, rather than just taking someone into court. That process is in our code language now. It applies, and it has a significant history under the Department of Law that I think draws a proper balance with the structure that I've just described in making sure that we constructively deal with the harassment issue. Let me just conclude before turning it over to you, Mr. Chairman, by saying that I started out referencing September 2017. I remember it vividly because within 2 weeks of the Harvey Weinstein story starting to explode out, I was before one of those candidates meetings where you get 1 minute to answer your question because there's so many other candidates in. And the question was, what are you going to do about pay equity? And there were some young high school seniors standing in the back of the room, but most of the audience was the type of audience that comes out for League of Women Voters types forums. And in my 1 minute, I decided at the end of the 30 seconds to say, and we will never deal with the glass ceiling until we also deal with the news that we have just been hearing. I believe it's almost 3.5 years later, as more and more stories have come out, as my own life experience applies to those stories, the glass ceiling is real. It is a part of employment discrimination, and harassment is very much a part of that glass ceiling in employment. Thank you, Mr. Chairman and members, for allowing me to present House Bill 2155.
Okay, thank you. Does anybody have any questions of the patron? The public, I know Tommy Strelka from Roanoke, my district, is on the line, would like to, he's one of the persons, members of the public would like to say something. Tommy, you still there? Tommy Strelka.
Yes, thank you, Senator Edwards. Hello, everybody.
Yes,
my name
please.
is Tommy Strelka. I'm a lawyer. I do primarily only really civil rights work for plaintiffs in the scope of their employment. And I'm talking in support of this bill because of the clarity that it provides. In federal law, a litigant kind of has to grope through, reams of precedent to try to understand the definitions of, some of these terms. And in some cases, the definitions have been left up altogether just by the courts. This bill codifies definitions that are workable, usable, clear, and concise. As it relates to the term supervisor, I think it's important that the language remain regarding individuals who can recommend termination under a 2013 U.S. Supreme Court ruling that affected the term supervisor as relates to Title VII. It's left with only individuals who have the authority to terminate. And just to let you know how cartoonish this gets, in a case I have against a major utility company, the only supervisor in the entire company is the CEO and president. That's the only supervisor under Title VII that exists at this major employer. And that there's no balance there. Finally, I just want to finish up by saying if anyone has concerns over the 5-employee threshold for jurisdiction with this law, I want to say, a good test for this is to look at what happened with Title VII cases. I'm the largest filer of Title VII cases in the federal courts in Virginia, and the threshold there is 15 employees. I've looked at our cases. I've never had a case against a 15 employee employer, a 20 employee employer, a 25, 30, 35. You have to get closer to 50. And this is common. Small employers are much harder to litigate against. They don't have the insurance. I mean, there's all sorts of factors. But my point being is that from our perspective, as someone who's in the trenches, we don't perceive this to open up the field as an assault on small business. I thank you, everybody, for your time, and have a wonderful morning.
Thank you, Mr. Stroka. And I agree with you. It's a very clear bill. I've done Title VII in federal court. They're hard to get past summary judgment because the judges typically are pretty hostile to this. At least they used to be. And I think it is a very well-written document. And thank you very much. Anybody else have any comments from the public?
Mr. Chair.
Yeah, Senator Morsi.
Thanks. For the last speaker, with regard to it being clear and unequivocal, could you turn to line 48, which I think you referenced, and it talks about workplace harassment, meaning unwelcome conduct, whether it's direct or indirect, that creates an offensive work environment. With all due respect, it's not that clear to me what exactly is workplace harassment. So here's my first question. Can a non-supervisor, say a co-equal employee, be guilty of workplace harassment? Just a word.
Mr. Stroka.
Yeah, well, for purposes of liability to the company itself, it's my understanding under this bill, the individual who's engaged, it has to be elevated beyond just a mere coworker. It has to be the supervisor who's engaged in the offensive conduct. And then it only becomes a problem if the employer was, put on sufficient notice of the incident.
Excuse me, I've read the bill. I just have some very narrow questions to help me decide how to vote. I've read the entire bill. And that unwelcome conduct, could that include asking somebody out on a date repeatedly?
Well, again, we have to look at who's doing this, okay? Because it creates an issue if it's a supervisor and the person has said no. If it's just a coworker, there's no liability there unless the individual makes a complaint about it, and then is in some way, shape, or form retaliated for making that complaint. It's not that what you just described would not typically fall under workplace harassment. I'll say though that the definition is written in such a way not to be overly umbrella, but to embrace the concepts of different types of harassment.
All right, last question on this area. Thank you, Mr. Chair. The offensive work environment, is that from the perception of the employee who perceives that he or she is being harassed? Or is
It's
that a legal definition
Mr.
somewhere
Strauch-
else?
Mr. Strauch, go ahead.
it's my understanding that it's based on an objective perspective of the hostile work environment, not subjective. I think it's part of the context of the analysis, of course, but it's my understanding, as it would follow with federal law, it's objective.
Okay. And final question, Mr. Chair.
Senator Morrissey.
Is there anywhere else in the code where we hold the employer vicariously liable as is done in section 142 for, well, period. That's full stop. Is there any other area where we hold the employer vicariously liable?
My area of expertise is only in civil rights and employment law, and I would not have the ability to comment on the scope of other sort of vicarious liability that could fall in the Virginia Code.
Let me rephrase. Or is this the first time in your area, your discipline, that we're inserting the words vicariously liable?
Well, I think as it relates to workplace harassment, I believe that's correct, but it merely just inserts language into a long precedential history of federal law in which vicarious liability is the norm.
Okay. All right. Thank you very much.
Any
Thank you.
further questions?
Mr. Chair.
Anybody? Yeah, Senator, who's that?
Peterson.
I can't hear.
Mr.
Senator
Chairman,
Deeds. Senator Deeds? I'm sorry.
Peterson.
Senator Peterson, okay.
Yeah, I have a question for this gentleman. I want to capture the testimony you just said, which was that you typically only sue employers that have 50 or more employees because they're the ones that have insurance and have assets. So, I mean, as an attorney, you're not going to sue somebody that has no assets, correct?
Well, that's correct. But I also don't want to be too reductive. I mean, these cases are important and brought also on principle of the matter. But a business is a business, and it's a practical consideration regarding the assets of the employer, of the potential defendant. And the other thing is that just in opening our doors open to field individuals, to let people come in and tell us if they have
Okay,
problems.
sir, I just asked you one question. I'll ask you a follow-up.
Yeah, Senator Peterson.
So, but one of the key points of this bill, maybe the most important point, is it reduces the threshold from 15 down to 5. So it will take in sole proprietorships, it will take in family-owned businesses, it will take in a whole raft of businesses that were not subject to this jurisdiction before that are going to now be brought in that, quite frankly, would likely not have insurance or not have the assets to withstand these claims.
Well,
Senator,
may I speak?
Mr.
That I
Go
would
ahead.
say that we open our doors up to anybody who wants to talk to us who has a problem at work. And in doing so, the first thing we ask is, who's your employer? What's the number of employees that they have? We get these from all over the state of Virginia. We just do not see people reaching out to us. I've been doing this for almost 15 years, from employers that are less than 20, 30. I can think maybe one or two with years in between. It is not, and I'm not here to argue the causation of that. I think there's multiple factors, but that's, as someone in the trenches, that's what we see. It's just not that a big of a factor.
Yeah, Senator Peterson, is there a motion?
Mr.
Would
Chairman.
you like to
Chair,
make
I
a
think there's
motion
some
from
more.
15 to
Mr.
5?
Mr. Chair.
Yes, Senator Boysko.
I believe that there are some people from the administration here to speak on the bill. I'd rather that we continue with the speakers, please.
And Mr. Chairman, I had a question of the
Senator
gentleman, too.
Senator Norman.
Before the gentleman leaves, are you still there, sir?
Yes, I'm here.
I don't practice in this area, but what I do know vicariously is that the cost of litigating and defending matters in the federal courts is extremely more expensive than in the state courts. Can you give me some idea, just based on a time and dollar amount, what you would end up investing in a case like this? Not whether you recover the attorney's fees, but what time and attorney's fees you would incur in pursuing a case of this nature.
Right. Well, it's a little bit of a different business model than almost every other practice, because our plaintiffs have just lost their jobs, and oftentimes they don't have the funds to pay their attorneys or us like the defense can pay their attorneys. We can't bill them straight hour per hour. I don't. I mean, maybe others do, but we typically charge them what would be, maybe, in some cases, we don't charge anybody anything because it's principal alone and, we want to take the case. But in most cases, we charge a small retainer that in the course of just working hour per hour in litigation is typically exhausted in the first 2 months. And then for the rest of the case, we are basically working on a contingency, seeking to get an attorney's fees award or some other settlement in the case. That's the business model. So it's not,
Mr. Chairman,
Okay,
Mr.
fine,
Chairman,
fine,
let me try
Yeah,
again.
go ahead, Senator Norman, make it quick. Thank you.
Hour-wise, what would you invest?
hundreds of hours. I mean,
Okay.
I don't perceive that to be a big difference between a state case or a federal case either.
Thank you very much, sir.
There are people who
Mr.
would like to
Chairman,
speak.
Delegate Watts,
Doug, yes,
could I-
Doug Watts, go ahead.
thank you so much. I should have mentioned in my introduction that Helen Hardiman from the Department of Law has a 9 o'clock case. If she could also address, since the emphasis is on what happens if we don't have mediation through the Department of Law, and so I'd like her to be able to answer questions also.
Helen Hardiman, okay, thank you. Helen Hardiman.
Good morning, Mr. Chair, members of the committee. I really appreciate y'all meeting to hear this bill. Helen Hardiman, I'm with the Office of Civil Rights at the Office of the Attorney General. Our small but growing team actually has a work share agreement with the EEOC, and so we investigate allegations of employment discrimination that happen in Virginia. I can tell you our process is strong and streamlined, and a lot of these allegations don't even get through intake. That's the first step in the process. And if there are other agencies that investigate particular environments of discrimination, particular types of industries, they get referred out. If an allegation does meet our jurisdiction, and it gets through intake, the first thing we do is offer the parties mediation. And a fair amount of them take advantage of that, and they can resolve it without any further sort of investigation by our office. If the parties don't mediate, the next thing we do is ask the employer to submit a position statement. They do not need an attorney to do that. Some do retain an attorney, and those position statements basically just respond to the allegations. Those I've seen anywhere from 2 pages, to 50 pages. And again, a lot of the times, an employer with a good defense or a complainant with relatively frivolous allegations, those become pretty clear very early in the process, and we can make those decisions based on the position statement. If it's not clear and we do need to investigate, some investigations are very precursory. We're basically just interviewing the parties. Others are more involved, where we do need to interview witnesses or ask for more documents. But the point is to get to the bottom of what actually happened and to determine, as a fact finder, as a neutral state agency fact finder, whether there's reasonable cause to believe discrimination occurred. If we do make that determination before we even issue a finding, we ask the parties again if they want to mediate or conciliate. If they don't, we issue the finding. The very small minority of our cases result in a reasonable cause finding. Otherwise, or in other words, that we find that there's reasonable cause that the employer discriminated against the employee. Most of our cases are no reasonable cause. And in either case, the complainant has to go through that entire process before they can step foot in court. So the last thing we do if we're not able to mediate it, or if it's no cause case, we close it and we issue a notice of right to sue. And then the employee or former employee, the complainant, is on their own to file in court and seek whatever remedy they feel is appropriate. So that's the process. I will tell you, I've worked on a handful of sexual harassment cases since I started at the office a couple of years ago. And some of them are no cause, and that becomes apparent pretty clearly on. And I don't have a problem issuing those findings. 2 other ones, it was pretty clear based on corroborating evidence and the egregiousness of the situation that they were cause. I'm talking about a waitress that was subject to sexual favors imposed by the owner of the restaurant in order to get time off for her birthday. I had half a dozen other servers corroborate that he did the same thing to them, except for the one male server that I interviewed. And he said, the boss never asked me to perform sexual favors, but he showed me a video of another waitress performing a sexual favor. Now, that woman only had a claim under the existing Human Rights Act because it was a less than 14 employer, because she quit, because it got so bad that she quit. And so this bill, I think it would capture that type of harassment that's occurring in Virginia workplaces for 6 to 14 employees.
Mr. Chair.
Okay, Senator Peterson.
Yeah, let me ask Nicole a question.
Go ahead.
Helen, I'm sorry, Helen, I apologize. The conduct you talked about, would that have been a cause of action under Title VII federal law, or is this separate and apart from that?
Mr. Chair, Senator Peterson, if there were 15 or more employees, yes, that would have been a cause of action under Title VII, but it was because it was 6 to 14 employees, Title VII didn't cover it, and we had to investigate it under the Human Rights Act.
So just follow-up question,
Peterson,
Mr. Chair.
Go ahead.
And I feel like, and you know, we had a battle with Senator McClellan's bill on definitions, and again, to me, you need to adopt the federal definitions or it's going to be chaos out there. But it seems to me the real issue of this bill is whether or not we take that 15 employee standard that's pretty much across the board right now and drop it down to 5. But I just had an attorney who said basically he doesn't take those cases, or there aren't that many of those cases. So I guess what I'm coming back to is the gist of this bill, we're trying to help that employee that's being harassed in a very small business, a 6 to 14 person business. And if so, I mean, is that really what this bill's about?
Ellen?
Mr. Chair, Senator Peterson, I mean, yes, I think this bill is about helping fact finders like me, as well as employers and employees, understand where the line is for workplace harassment. And there's a lot of cases that I've heard folks talk about that are clearly below the line. But there are a lot of really egregious situations that are clearly above the line. And I think what Delegate Watts, you know, not to try to crawl into her head, but I think her point is to help draw that line more clearly. And yes, to make sure that Virginia does not stand for workplace harassment, even at mid-size employers.
Mr. Chair, can I ask a follow-up, please?
Senator McClellan.
Thank you, Mr. Chair. Helen, I think part of the point of dropping the threshold to below 15 is to allow employees at smaller workplaces the ability to get to the administrative process, which you cannot go to court unless you have gone through the administrative process and there is a finding that you have a valid case. But you, as you just testified, usually when you get to the administrative level, it's resolved and it doesn't go to court. Can you just sort of expand on that?
Yeah, Helen?
Mr. Chair, Senator McClellan, yeah, thank you for that. Exactly. If anyone wants to bring these allegations whatsoever, violations of the Virginia Human Rights Act, the Virginia Values Act last year actually made clear that folks have to come through OCR, through the Office of Civil Rights at the OAG. Just like in Title VII, they have to go through EEOC and basically get, I mean, I estimate it's basically like a probable cause. It's a reasonable cause, it's higher than probable cause, vetting. And so this bill, yes, by taking the threshold down and making it prohibited discrimination, workplace harassment, prohibited discrimination at employers that employ between 6 to 14 or 5 to 14 employees, actionable, they would have to come to us before going to court. So it would give those folks access to the administrative process, which is considerably less expensive than courts.
There are other people who would like to speak, I believe. Are we finished? Okay. Megan Healy, I believe. Is Megan Healy?
Chair, members of the committee, Megan Healy, Chief Workforce Advisor to the Governor. I'd like to thank Delegate Watts for carrying this bill on behalf of the administration, as well as Senator McClellan for carrying similar legislation. A couple clarifying points I would like to make. Since 2017, there's actually been 19 states that have strengthened their harassment in the workplace. We have states like Texas who actually go one step further than Virginia, that you can't harass against interns, independent contractors, volunteers, a whole list. We also, when talking about that 15 threshold of number of employees, we actually have over 35 states that have less than 15. Thinking about our neighbors to West Virginia, they have zero tolerance for any type of discrimination, specifically harassment. And we even have even Republican states that have less than 15. So I think that's really, really important that when we look at small businesses, no one should be discriminated or harassed. And I think that Helen and OAG's office and Delegate Watts did a great job, again, emphasizing this administrative process, that this bill is pretty straightforward. We actually have advocates that do not like the bill anymore because they don't think it's far enough for our workers here in Virginia. But I think it's a great step forward for Virginia and the 4.5 million workers that we try to support daily. Thank you.
Okay, Andrea, any questions of The witness? Okay. Andrea Johnson?
Good morning, Chair and committee members. Thank you. Andrea Johnson with the National Women's Law Center in support of HB 2155. I just want to emphasize that the language in this bill, as this question has come up several times, is pulled from existing federal case law and follows the remedial intent of those laws. And really the goal here is to ensure a fair, unbiased process for both employers and employees that gets to the bottom of what happened. Sort of Megan alluded to, we have concerns about the language the business lobby included in the bill to address when employers are to be held liable for harassment. That liability language is a copy paste of federal liability standards that are stacked in favor of employers. But we still believe that the bill, the overall clarity provided the bill is important, and thus we are supporting the bill.
Okay, thank you.
Thank you.
Any questions of the witness? Anybody else? I think there are some others. Who's next? Doris Krause.
Mays, please go ahead.
Doris, welcome.
Yes, Mr. Chairman and members of the committee. I'm Doris Krause Mays, President of the Virginia AFL-CIO, and we are in support of this bill. We feel that all workers, no matter how many that work there, should be able to work in an environment that is free of harassment. So we would really appreciate this passing of this bill. Thank you.
Thank you. Any questions? Next person. Who's the next person? I don't see it. Who's next?
Those in favor of the bill, please raise your hand to indicate that you'd like to speak in favor of the bill. Galina Varchina, please go ahead.
Good morning, Mr. Chairman, members of the committee. My name is Galina Varchena. I'm the Policy Director for Narrow Approaches Virginia, and we absolutely support the intent of the bill and the vast majority of the language in the bill. Just like Andrea mentioned earlier, we have some concerns about the liability language, but overall feel that the bill does more good than harm for employees in Virginia. Thank you.
Okay, any questions? Thank you. Next.
Sushila Varki, please go ahead.
Good morning, Mr. Chair and members. I am with Virginia Poverty Law Center, and we thank Delegate Watts for bringing this bill yet again, and we support the bill. Thank you.
Okay, thank you. Next.
Kenda Sutton L, please go ahead.
Hi, I am the Executive Director of Birth and Color RVA. We are definitely in support of the bill. We don't feel like it should be of so much focus on the 15 for small businesses, because we do know that in the state of Virginia, small businesses get away with a lot of things that they should not get away with. And so profit over people is something that we need to pay attention to and what we need to stop. As a person who was 16 and harassed, in a small rural county, and no one could ever do anything about it because there was only 5 employees, I definitely support this bill.
Okay, thank you. Next.
Camille Cooper, please go ahead.
Camille Cooper, go ahead. Camille Cooper.
Camille Cooper, please unmute and go ahead.
Okay. All right. Next.
Jonathan Iglesias, please go ahead.
Yes. Good morning, Mr. Chairman and members of the committee. Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We are wholeheartedly in support of this bill as a measure to guide Virginia businesses of every size and without undue burden in reaching benchmarks for ensuring worker conditions in which every employee can feel safe and secure. We believe this is a good policy for all Virginia businesses, and we hope that it's the will of the committee to adopt this policy.
Thank you. Next.
Susan Horning, please go ahead.
Hi there. Good morning, everybody. I am Susan Horning. I'm actually opposed to this bill, and I'll give you the reasons why. First of all, we want to point out that as was mentioned before, the Judiciary Committee has already blocked a Senate bill that's very, very similar to this one. So we do believe this to be what you want to call the proverbial second bite of the apple. That's number one. Number two, we believe that this bill will make the unstable Virginia economy, prevent it from recovering. You know, so many people have been laid off because of COVID, and so many businesses are struggling right now because of COVID. This bill pressures employers to preemptively punish and dismiss employees for conduct that does not meet the existing definitions of sexual harassment and workplace harassment. This increases business exposure to liability for activities that are unrelated to the business. A few things we want to talk about is, number one, the definition is too vague. It's a very low threshold. It's extremely low. We view it as allowing any claimed trivial behavior to be harassment. The second thing is this bill includes work harassment or issues that are outside of the workplace. There's a real problem with that. So now all of a sudden the employee is, having to deal with issues that are outside of the four walls of their business. For example, one of the definitions, it says conduct may be workplace harassment regardless of whether the complaining party is the individual being harassed. So read clearly their definitions. You'll see it's very, very vague. The other thing we have issue with is how the employer liability requires immediate corrective action, including termination without knowing the facts or making a fair decision. This punishment before investigation approach we believe is very unworthy and in Virginia. Okay, so our thought is there's strong laws already. This just simply goes too far. And frankly, to hear from the delegate that this has all been written in response to women wanting some sort of more protection via the Me Too movement, et cetera. As a woman, I feel like there already are existing laws that women should not be elevated above men. The laws should be over-encompassing everybody. You should not be saying we're proposing a law because it protects women.
Okay, thank you. Nicole Riley? Nicole Riley?
Yes. Hi, Mr. Chairman, members of the committee. Nicole Riley with NFIB, and we represent about 6,000 small business owners. For our members, they are concerned about the fact that this threshold does drop. If that isn't the case, that these cases really don't go to those, then why are we dropping the threshold, I guess would be my question. Second of all, it was mentioned that, in federal court, we do have summary judgment where a lot of these can be dealt with before going to the courts. Virginia, we don't have summary judgment. So there is not that protection for businesses to be able to make their case before taking a case to court. Third, we certainly appreciate the administrative process that has been set up under the Virginia Values Act, but that's not even a year old yet. So there's been no report, no understanding of how much demand there has been, how much outreach is done proactively to the business community to educate employers, particularly small employers who, again, have no legal resources and may find themselves in this situation. So it's for those reasons that we oppose the bill.
Thank you. Next.
Julie Strandley, please go ahead.
Hey, good morning. Thank you for holding this hearing, and thank you for Delegate Watts' leadership on this issue. As a former practicing attorney, both representing management and plaintiffs, I strongly support the bill and urge the committee to adopt it. It is very important that the law is clear. There's nothing worse than to hear that your cause of action is precluded because of a lack of clarity. The other key component is that it does provide best practices for business. The preventative measures are extremely important, and thank you very much for your consideration.
Okay, thank you. Next.
Birdie Jamison, please go ahead.
Good morning. I would like to thank Delegate Watts also for her leadership in this and on this particular bill. I would like to say I strongly support it. I come from a background that is a legal, male-dominated legal field as a defense attorney, Commonwealth's attorney, assistant attorney general, and a judge for 24 years. And I think that this is very much needed, and I strongly support it.
Okay, thank you. Anybody else in the public?
We have two more speakers, it seems.
Go ahead. Yeah, two more. Go ahead.
Jody Roth, please go ahead.
Good morning, Mr. Chairman, members of the committee. Jody Roth on behalf of Virginia Retail Federation and Virginia for a Strong Business Economy, representing over 30 business organizations across the state. And we do stand in opposition of this bill. Based on the comments of Ms. Nicole Riley and Ms. Horning that just recently spoke. Thank you.
Thank you. Next.
Camille Cooper, could you please unmute and go ahead?
Camille. Okay. All right.
There are no other speakers at this time, Mr. Chair.
Thank you very much. I got on the list in the queue is Senator Sherrill.
Thank you, Mr. Chairman. I had a legal question, and I don't know who can answer it, but
I don't practice in this area, and I don't pretend to even begin to understand all the nuance, but I heard some discussion earlier about coworker liability. So in other words, situations where there's a situation going on between two coworkers, and not between the worker and management, but between the coworkers. And the section of the bill that has to do with that is on lines 153 to 55. And it talks about an employer shall not be vicariously liable or automatically liable, but shall be liable if the employer, I guess, knew or should have known of the conduct, unless it can be shown it took immediate and appropriate corrective action. And that section deals directly with coworker liability. Then I looked at the top, and it has a list of factors that are supposed to be considered. It's not clear to me how the factors in 153 interrelate to each other, sort of whether one trumps the other. I would think that the 153 trumps things. And just trying to figure this out, I went and looked at the EEOC website. In the EEOC website, it says that the employer can avoid liability if it takes immediate and appropriate action after an employee complains. And with regard to lines 153 to 55, there doesn't seem to be that element there that an employee has to complain to management before liability arises. Okay. So it strikes me, Mr. Chair, I'm trying to understand. I mean, I keep hearing that this is, perhaps declarative of federal law or clarifying, but it also seems to me to be inconsistent in some respects. And if somebody could clarify for me exactly how that coworker liability scenario works, it's important, because you're talking about a situation where you have some employees doing something. The employer might not know that anybody is bothered by it, but now they become liable for it. And it looks to me like under federal law, they're not liable, but under state law, they maybe would be, depending on how those two code sections interrelate. I don't understand how they relate to each other, the way it's drafted.
Charles or Helen, anybody want to explain that very quickly?
Yes, Mr. Chair. Senator Serval, this is Helen Hardeman from the OAG. Senator Serval, that's a really good question. I think when you're in the coworker bucket, well, when you're in any bucket, I think you need to distinguish between the two analytical phases of these cases. The first is whether harassment occurred. Was the conduct bad enough to alter the terms and conditions of someone's employment? And that's where you look to all of the factors and the totality of the circumstances. Then and only then, if you have a coworker harassing another coworker and the behavior is bad enough to constitute harassment, do you then go to phase two, which is, can the employer be held liable for that harassment? And when you're talking about coworker on coworker harassment, that's a negligence standard. So the employer would have had to have known, which usually is going to be the person being harassed is going to report it, and they fail to take prompt, immediate action. I've seen there's a lot of cases in court where there's been really bad harassment occurring, coworker on coworker, but the employer did the right thing. As soon as they got the report, they investigated it, and if they found harassment was occurring, they remediated it. They are not liable for those situations.
Mr. Chairman,
thank you.
Follow-up question.
Who's this? Senator
Sherville.
So quickly, could we have three other people want to speak?
Your Honor, Mr. Chairman, I get that, but this is a very complicated bill, and I appreciate the time pressure. But I guess to Ms. Hardeman, what I'm trying to understand is the EEOC website seems to say that the employee has to complain. The employee has to complain to the employer, and the Virginia code doesn't seem to require that. So I'm trying to understand, is Virginia law changing what federal law is on that point?
Let's move on. I hate to say, but the chairman of the Commerce and Labor Committee is pushing us to move along. Okay, Senator McClellan, and then Senator Boysko, and then Senator Openshain. Senator McClellan.
I think I've already made the point
Okay.
I wanted to make is most of these cases go to and are resolved through the administrative process at the Attorney General's office. But they can't even get there for employees under workplaces under 15 unless the employee loses their job. What this bill is trying to do is provide a mechanism for those employees who face harassment to get to the administrative process. If the case is egregious enough to warrant going to court, it it should go, no matter how many employees there are, but it will have already been vetted through the administrative process and have to exhaust the administrative process before going this. This bill essentially codifies what is existing federal law.
Okay, thank you. All right, Senator Boysko.
Thank you, Mr. Chair. I just want to ask our patron if she can tell us who worked with her to get this bill together, what the stakeholders were. I understand that it's a pretty broad group, including the Virginia Chamber of Commerce. Just like to have her share that with us and make sure that she gets a chance to.
You're very kind, Senator, but I will specifically say that Edward Mullen, because of a long-time relationship, was the one who brought to me the language on line 137, 159. But in part because of the work that Senator McClellan was doing on this, I know that he had worked with Helen Hardiman looking at the case law that she worked with to draft this language reflective of case law. So that particular language is there. The language from 160 to 162 came from Helen Hardiman directly. It is what is used as the standard as far as supervisor in Virginia.
All right, thank you. Senator Obenshain?
Yeah, Mr. Chairman, I just want to make a couple of comments, and I'll try to do this real briefly. You know, and I appreciate the work that has gone into this. I mean, we have spent a lot of time on this, both on Senator McClellan's bill here and on the floor, and on this bill. A couple of things. I mean, one, I'm troubled by the language in here that indicates that a single incident can constitute harassment. I mean, how do you hold a business liable for a single act? This clearly contemplates that, even though there may be defenses. It covers acts outside of the workforce. Plaintiff doesn't have to be the victim of the harassment. There are no caps on damages, and that's a big one. No caps on damages. Even Title VII has caps on damages, and you know, we've spent a lot of time talking about insurance and insurance rates. Nobody has talked about the impact on small businesses of purchasing employment practices liability insurance. This is going to have a huge impact on the cost of insurance coverage to protect small businesses. So those are my concerns. It's not inviting further comment from the patron or any of the others, but I just wanted to express a few thoughts.
Thank you, Senator Obenshain. No one else is asked to speak. Is there a motion?
Move to report.
Been moved to report. Is there a second? It's moved and second to report the bill. All in favor of the motion and re-refer to finance. Report the bill and re-refer to finance. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 6, no 7.
Ayes 6, no 7. The bill fails to report. Thank you all very much.
Mr. Chairman,
yes,
Senator
Norman.
Before you leave, I have another matter to bring up. Mr. Chairman, I know that judicial interviews are taking place later today, and I want to move that Judge O'Berry be certified. She's previously been interviewed and is not on a list, but the certification is different from election.
We've already dealt with that, I believe.
It doesn't matter whether we dealt with it. A motion has not been made to certify, and I so move, and if it is, then I'll move to reconsider it.
Mr. Chairman, two things. Number one, is this on the docket? And number two, since this is, by my count, the third time for this motion, would it not require unanimous consent?
Well, it's not on the docket.
Thank you.
So.
Mr. Chairman, I don't think it has to be on the docket. We've done it on the floor of the Senate.
Well, she was not certified on the floor. It's not on the docket.
Mr. Chairman, there has not been a vote on it.
Mr. Chair.
And she is entitled to the dignity of a
Senator
vote.
McClellan.
Mr. Chair, I will note that there was at least one other instance where a judge was brought up to be certified that was not on the committee docket. So this is not without precedent.
Mr. Chairman, it may not be without precedent, but number one, and contrary to what the senator from James City County said, this is the third time. It was done at the initial meeting. Nobody moved to certify her. It was done when the gentleman from Franklin County did it, and this would be the third time. But I don't think we have to get to that because it would require unanimous consent. If this isn't not on the docket, it's the chairman's prerogative not to consider it. And the two senators from this jurisdiction, Senator Hashmi and Senator Morrissey, are inextricably opposed. I don't know why we keep visiting this issue.
Yeah.
Mr. Chairman, it doesn't have to be on the docket. This is a precedent that we've done. And with all due respect, we have passed judges by before and then come back and certified them sitting on the floor of the Senate. And I don't care what the delegation is, because there's a difference between certifying a judge and electing a judge. And just because the certification takes place does not mean that the judge would necessarily be elected. But she is entitled to the dignity as a sitting judge to have a certification.
Didn't we do that?
That's right.
We've already done it.
Motion to adjourn, and I believe that takes precedence.
All right. The motion has been made to adjourn. The committee will rise.
There's no vote on it, Mr. Chairman. You can't unilaterally decide that.
All right, a motion to adjourn. All in favor of the motion to adjourn, vote aye. All opposed, no.
Ayes 4, noes 8.
We've not adjourned, okay.
I would move that Judge O'Barry be certified.
Does this require unanimous consent, Charles? Karen, Kristen?
Mr. Chairman, that's a question for the clerk. That's not for us.
All right, clerk, does this require unanimous, John? Unanimous?
Mr. Chairman, no vote has taken place. There's nothing to reconsider.
Does this require unanimous consent to bring this back up? Because we already dealt with this, I believe, haven't we?
Let's see.
Mr. Chairman,
Mr. Chairman, why do we have to get to that point when the chair, who has the authority to run this committee, just like when the Republicans were in control, they ran the committee? Why are we even going forward when this matter hasn't been docketed on this docket?
Mr. Chairman, it does not have to be
I want
on
to hear
the docket.
from the clerk.
And there is
Does
not a
unanimous consent to bring it up?
It is not a reconsideration.
Just a minute, Senator Norman.
Does not need unanimous consent.
Okay, all right. Then the motion, is there a motion?
Move to certify Judge O'Barry.
Is there a second?
Speaking to the motion, Mr. Chair.
Senator Morrissey.
Thank you. Notwithstanding the protestations from the senator from James City County, this matter has gotten, by my count, 3 extensive judicial vettings. Chesterfield County is its own judicial district, only judicial circuit. The local branch of the NAACP voted on their executive committee unanimously asking the delegation not to certify her. The Legal Redress Committee spoke up and they asked that she not be recertified. 2 professors from Virginia State University whose students were regularly before Judge O'Barry said that she was, quote, a danger to the black and brown community. There were over 35 lawyers that signed a letter saying that they were opposed to her because of the way she conducted matters in Chesterfield County. Of the 47 people that were up for re-election, she was at the very bottom. Another senator told me over the last 4 years, 186 judges have been up for a reappointment. She ranked at 185. This matter is between the Chesterfield delegation and not the gentleman from James City County. You've ruled twice, Mr. Chairman, that you're not going to consider matters that aren't on the docket. I have no idea what the machinations are from the other side, but we have said repeatedly we're not going to interfere with other people's bailiwick. So, Mr. Chairman, I'm going to ask you again to rule that this matter is not on the docket and for a myriad of reasons that she not be certified.
Mr. Chairman, there is a pending motion that has been seconded, and the senator's request is out of order and inappropriate. If he wants to get
I'll
in.
decide whether it's out of order or not. This is not on the docket.
Thank you.
So the question is, we voted not to adjourn, so where are we now?
I made a motion, should be certified.
It's back in your docket.
One at a time. All right, Senator Norman, go ahead.
Mr. Chairman, I made a motion that was seconded that she be certified, and that is the matter before the committee and nothing else in spite of the protestations.
Okay, well, let's do this. Then if we have a motion, we have not adjourned, it's been seconded. So all of the motion.
Let me call the roll.
You call the roll to certify. Vote aye, all opposed no.
Senator Saslaw? Senator Norman?
Aye.
Senator Lucas? Aye. Senator Obenshain? Senator McDougal? Aye. Thank you. Senator Stewart? Aye. Senator Stanley? Aye. Senator Deeds? Aye. Senator Peterson?
Oh, brave boy.
Senator Serbo? No. Senator McClellan? Senator Boysko? Senator Morrissey?
No.
Senator Peake? Abstain? Uh-oh. Mr. Chairman? 9 yeas, 3 nays, 2 abstentions.
All right, that having been done, committee will rise. And thank the staff so very much for coming in on this special event on this day. We appreciate it very, very much. Y'all are absolutely wonderful. And again, the committee will rise and the committee will adjourn.